2 Wants to Know's Ben Briscoe here with a look at what the Supreme Court decision means for abortions in North Carolina. Last Thursday, before the ruling, out of the 40 weeks of pregnancy, women in North Carolina could get abortions up until the point of viability, when the baby could live outside the womb. Medical experts say that differs for each pregnancy, but it's normally right here around 24 weeks. Now here's where things could change. Back in 2016, North Carolina passed a law banning abortions except for medical emergencies after 20 weeks, right here. A federal judge overturned that. He said we had to go with the viability rule because of Roe versus Wade. But now that Roe versus Wade is no more, leaders in the General Assembly, they want to go back to that 20 weeks or half of the pregnancy rule. The Attorney General's office for North Carolina says the impact of the Supreme Court ruling on abortions between 20 and 24 weeks will need to be determined. So, what happens in that time frame? We asked a doctor from North Carolina's A&T Nursing School.
At about 20 weeks, the baby is the size of a bell pepper, and you start having what's called quickening, and the mother can feel the baby. In about 24 weeks, that's when the baby starts to develop eye opening, skin thickening, and reflexes. And so there's not much difference, but besides the baby's growing a little more.
So in that 20 to 24 week time frame, the fetus goes from being the size of a bell pepper to about an ear of corn. And North Carolina lawmakers said back in 2016, there was one other development that made them really want to focus in on that 20-week ban. They said that's when a fetus starts to feel pain. Now, medical researchers have found conflicting evidence and aren't sure that's when that starts. Again, it is unclear when or if North Carolina will revert back to that 20-week rule. But the Attorney General wants you to know, in North Carolina, even with Roe v. Wade overturned, abortions prior to 20 weeks, as well as abortions that are medically necessary, will remain legal, unless the General Assembly changes the statutes and the governor either signs the new provisions into law or a gubernatorial veto is overridden.